On the morning of the 16th of January 2025, Femi Otedola, chairman of First Bank, initiated contact with Dr. Ernest Azudialu Obiajesi, GMD Nestoil. His objective was clear: to buy a 16% equity stake in Nekonde Energy. What followed was not a casual inquiry, but a sustained, calculated pursuit. Persistent phone calls, relentless text messages to Dr. Ernest. By the 28th of January 2025, Dr. Ernest responded, firm, definitive, unambiguous. There were no shares of Nekonde Energy available for sale. That should have ended the conversation. But it didn't. Aggrieved and evidently dissatisfied, Femi Otedola, in concert with First Bank and a receiver manager, approached the Federal High Court in Lagos, secured a Mareva injunction, a powerful legal instrument designed to freeze assets and, in many cases, to preemptively cripple a counterparty. Now, as you follow this narrative, consider this critical fact. At the time these claims were made, Nekonde Energy had already repaid to lenders $1.025 billion. Let that sink in. How can anyone now say Dr. Ernest does not pay, a man that has paid back double what he borrowed on just one of his companies? So banks gave Dr. Ernest's company Nekonde a loan of $640 million in 2011. Just listen, one of the man's companies has paid the banks almost double the amount the banks gave to him. Yet, from inception in 2011 through 2026, Nekonde had repaid over $1 billion. That is not default behavior, that is performance. Now fast forward to 2025. Nekonde Energy achieved a remarkable operational milestone. Production from OML 42 surged from 4 million barrels of oil per year to an astonishing 15 million barrels of oil per year. An estimated $1 billion in revenue were distributed in accordance with statutory and contractual obligations. The federal government received royalties and taxes. NNPC received its revenue share. Operational and production costs were settled. And importantly, lenders to Nekonde received $168 million repayments. That's approximately 235 billion naira in 2025 alone. Yes, 235 billion naira in a single year. Now compare that with the allegations against Nekonde and Dr. Ernest. Now let's take a dive into the takeover scheme. Quietly planned, loudly executed, courtroom, media, police, all part of the plan. This is how one courtroom weapon nearly redefined corporate Nigeria. October 22, 2025, a date that will always be remembered in Nigeria's corporate legal history. Inside a federal high court in Ikoyi, Lagos, a single proceeding, ex parte proceeding, triggered a financial earthquake. A Mareva injunction was granted. The target? Nestoil Limited. And its energy arm, Nekonde Energy. Now understand this. A Mareva injunction is not ordinary. It is a draconian equitable remedy imported from English jurisprudence, designed to freeze assets without prior notice. No hearing, no defense, no opposing voice, just one side of the story, one lawyer, one narrative, one courtroom. In this case, it was Femi Otedola and First Bank present. And once armed with this order, it becomes a corporate chokehold, because with it comes power. Power to freeze bank accounts, power to shut down operations, power to paralyze a business overnight. And in some cases, power to appoint a receiver. A receiver, not just an observer, but a corporate undertaker in waiting. He steps in, takes control of assets, while the actual owners sit and watch their company slip through their fingers. Imagine this, your company, but you no longer control it, your accounts, but you cannot access them, your case in court. But someone else appoints lawyers to represent you, and this was not isolated. Multiple firms have faced similar legal artillery, from power generation giants to oil and gas operators. So this is not the first injunction Femi Otedola has engineered. There has been one for General Hydrocarbons Limited, owned by Nduka Obaigbena, the owner of This Day newspaper and Arise TV. Other firms that have gone through Mareva injunctions include Sahara Power, Egbin Power, Ikeja Electric, Kepco Energy Resources Limited, and NG Power HPS Limited. It will be safe to say that over 30 companies in Nigeria have had the Mareva injunction applied to them in 2026 alone. The Mareva injunction had quietly evolved into a strategic weapon in high-stakes finance disputes. Then they went for Nestoil. But here is where the story turns. An appeal court supported and reinstated the injunction after another court vacated it. And next, April 10, 2026. The Supreme Court of Nigeria intervenes. In a landmark pronouncement, it redefined the balance of power in receivership disputes. The court held, Companies under receivership retain the right to legal representation of their choice. It's a principle that had been dormant for over 40 years. Reawakened. Translation? The era of silencing companies inside their own cases was over. Then on June 1st, 2026, another decisive blow. The Supreme Court ruled that the Court of Appeal abused their judicial powers, that the earlier takeover actions against Nestoil and Nekonde were null and void. And just like that, accounts were unfrozen, assets restored, board control returned, operational access reinstated, due process reclaimed. But beneath the legal fireworks lies a deeper issue: forensic financial transparency. Nestoil had called for an independent forensic audit to determine the actual debt exposure, a request still unresolved. Because in complex credit disputes, numbers don't lie. But narratives often do. History reminds us, in prolonged banking disputes, outcomes can reverse dramatically. Claims today can become liabilities tomorrow. And this is where information warfare enters the arena. Selective reporting, half-truths, sponsored narratives. Because in high-value litigation, the courtroom is only one battlefield. The media is another. So where are we now? The case returns to the High Court. But this time, everything has changed. Nestoil and Nekonde are no longer outsiders to their own legal fight. They are inside their offices, inside their accounts, inside the courtroom, with their own lawyers, their own voice, their full legal rights restored. And that forensic investigation into the First Bank accounts will not be determined by Femi Otedola or an acquired destructive legal weapon. And this is no longer a one-sided proceeding. This is now a contest of equals. And perhaps that is the real victory. Not just for Nestoil, but for every Nigerian business that believes justice should never be decided by one man, standing alone in a courtroom. Because in law, as in business, fair hearing is everything. And for the Mareva injunction, this is the tool Femi Otedola has attempted to allegedly use to take over businesses as alleged by media records. Forget the noise, the fluff, the unfounded narrative by paid media. The empirical data tells a different story. It points to a high-performing indigenous energy company driven by measurable growth, disciplined financial commitments, and operational excellence. A company led by a man who, within a single fiscal cycle, scaled production from 4 million to 15 million barrels. That is not coincidence. That is competence. Operating under the FTSA framework, he adhered to due process, applied due diligence, and delivered tangible value to Nigeria's oil output. Such leadership should be incentivized, not undermined. Nestoil, another of Dr. Ernest's company acting in good faith, formally requested a restructuring, debt restructuring and rescheduling, and committed to repayments under one fundamental condition: a comprehensive audit and forensic examination of the loan accounts. Standard, reasonable, legally sound demand. However, First Bank and Femi Otedola declined. No audit, no forensic review, no transparency, no questions, no inquiry, no reconciliation, just one directive: pay. Now here's where the narrative takes a more troubling turn. Nestoil's accountants made repeated formal requests for access to loan account statements. Yet, in a correspondence issued by FBNquest signed by Wale Adebanjo, it was expressively stated that FBNquest did not maintain loan account statements and did not act as the facility agent. A financial institution, in a transaction of this magnitude, asserting the absence of loan account records, that is not just unusual, it is deeply concerning. This is the same institution that approached the court to obtain a Mareva injunction, a legal weapon capable of enabling a hostile financial takeover. And yet, no documentation, no statements, no verifiable breakdown of the alleged obligations, just enforcement without disclosure, and that raises serious legal and ethical questions. So the question is, if Dr. Ernest, Nestoil, and Nekonde are companies that are actively doing business, actively repaying loans, actively seeking to restructure loan facilities, actively seeking forensic audits and examination of loan accounts, actively requesting for bank statements of loan accounts, actively growing production in OML 42 in leaps and bounds, why then did Femi Otedola go after Dr. Ernest's companies with Mareva injunctions? Then obtained the ex parte in Federal High Court, and another ex parte obtained restoratively in the Court of Appeal in a judicially tragic way. Is this a backdoor to grab Nekonde shares by force? This is a company that has been in business for more than 35 years, that grew enormously within 1 year, earning $1 billion in oil sales revenue in 2025. Let's go back to the 28th January 2025 phone call between Femi Otedola and Dr. Ernest. The answers we are all looking for may just be staring at us there, hidden in plain sight. Listen to this. They told the court they want Nestoil and Nikonde assets. What they did not tell the court is that Nestoil has paid back over $1 billion in principal and interests. In closure, here's your takeaway. Between Nestoil and a consortium of lender banks, with First Bank trustees and FBN Quest driving the process, Nestoil requested that it wants a comprehensive forensic audit of each of the loan facility it had in each of the banks, before all the banks will pour their different loans into that one basket called the Common Terms Agreement. The bank's response to Nestoil? No, not now. You are wasting time. We are doing you a favor by all coming under one umbrella so that your loan facilities will be easier and better managed. If you waste more time, we will back out of this transaction. We can always do the forensic audit later. Under pressure, Nestoil signed the Common Terms Agreement. Then came more pressure. Pay now, pay more. Nestoil requested for loan account statements, declined. Recently, under strict regulatory compulsion, the bank started squeezing out the statements, and Nestoil started checking. Total monies paid by Nestoil to the lender banks from inception to date is $1,080 million. Yes, you heard right. More than $1 billion US. Total amounts borrowed by Nestoil from lender banks is $1,057 million. This means that Nestoil has actually paid back more money than the loans it borrowed. And next is a brief outline and what you should know about Nestoil. As a very active going concern, Nestoil funded its business with equity and loans. Before the restructure and aggregation of different loan facilities under a single Common Terms Agreement, decades of creating great value in the oil and gas industry for Nigeria and Nigerians, a company that truly embodies local content and value creation in Nigeria for Nigerians.